and really sort of embody the idea of the equal enjoyment of all rights and freedom in the Constitution, right? So I'm just bringing in this idea of necropolitics as another lens through which we could see the specific legal silences and sort of the fact that this has been on the books for a long time and how long it's taken for this case to be brought and why this was the case. And again, this theme of like, what was it in Union for Refugee Workers that wasn't seen? Perhaps it was this, the fullness of the humanity of the people who were subject to the harm. And not because the court is bad, not because the individual judges or legal practitioners are xenophobic per se, but just because the nature of law is in this way. Those who are not at the center of who the state wishes to see fall at the wayside. And this can be sort of one lens through which we could see the specific legal provision, because I agree with Muchengetti's earlier analysis, the legitimate purposes simply just don't exist. They are xenophobic. They will perpetuate stigma and stereotypes about non-citizens. And I'm very optimistic about what could happen in the courts in this case. But listening to Pia now, perhaps I shouldn't be as optimistic, because there is this broader politics of not really recognizing the harm that's experienced by those that the law refuses to fully see. So yeah, just adding that to the conversation.
Yeah, thank you for unpacking that issue, that you've vehemently refused the current governmental purpose that the government alludes to be available for Section 24 to be operation. If I may, Prof. Porter, I know you love this section so much, Section 9. My previous speakers have alluded to the fact that there is a lot of unfair discrimination due to the provisions of Section 24(2)(b), which is one of the arguments that they actually put in their founding affidavits that are in my possession. Would you mind unpacking that element, and in the context of this discussion, probably give us your opinion on whether there is that infringement that is being averred in the founding affidavits?
Thank you very much. I see I have the honor of doing the academic lecture, which I'm actually not going to do because I think it would keep us here for quite some time. But certainly, I've read the affidavits and also the affidavit, and also had a look at the Union of Refugee Women decision. A couple of comments. The argument, as I see it, is based on Section 9(1), which would be the argument that there's no rational connection, there's no legitimate government purpose. And then the other argument and the alternative is based on 9(3), which is the discrimination on analogous ground argument. And in my view, I believe that the applicants should be successful on both if the alternative is not argued. Firstly, on 9(1), I think what we see in here, and Nomfundo has alluded to this actually very strongly, and that is government's attitude to persons who are not citizens. And we've seen it not only in the arena of the Legal Practice Act, but you've seen it across the board. There have been amendments to the Refugee Act, for example. The National Health Insurance Bill, which you may know, also contains retrogressive measures taking away rights to medical treatment for non-citizens. So this appears to be a sort of governmental strategy, perhaps not explicit, but certainly there in the background and impacting terribly on people who live in this country and who believe that they are entitled to many of the rights in our Constitution. So insofar as 9(1) is concerned, an arbitrary exclusion, personally, I think that if one looks at cases such as Andrews in Canada, which is a very, very similar case, and also at Union of Refugee Women, specifically actually paragraph 60 of that case, I see that the court there distinguishes lawyers to private security industry. So that's there, and seems to indicate that if this were in an act such as the Legal Practice Act, that it wouldn't necessarily be a legitimate government purpose. So that's on 9.1. 9.3 requires proving that the discrimination is unfair. And, obviously one would take into account the position of the complainants in society, the impact on them. Here we would see the continued harm that is caused by such exclusions. But on top of that, insofar as whether I suppose it would also come through in the Section 36 analysis, and I think it was the third leg of your argument there, Mchengi, which was less restrictive measures. And the only thing that I see that saved the security service provider exclusion was the exemption clause, which was available. And there's no such exemption clause in the Legal Practice Act, which means that there's no avenue for people to try and assert their ability. On top of that, bear in mind that one of the requirements to be admitted as an attorney or as an advocate is that you're a suitably qualified person. That's a specific requirement on its own. So now to say and to somehow conflate fit and proper person with your residence status is it's double whammy if you're a non-citizen. So in my view, I think the case would be successful both on 9.1, if not 9.1, because we know that that would be an easier leg for government to overcome. But on 9.3, I believe that this discrimination would be unfair and certainly not justifiable in terms of Section 36 of the Constitution. But it's a fantastic case to illustrate how Section 9 works. And thank you. I'm going to be using it with my human rights law students in about a week or so to come. So over to you. Thanks.
Yeah, I just feel sorry for your students this year, because that means that on top of the over 26 cases that you prescribed, they'll have an additional one that they...
No, not 26 cases that I prescribed. Somebody's telling stories about me here in the background.
Thank you so much.
Case. It could be a case study.
Thank you so much. I think some of our panelists have been too quiet. If you may allow me, Nkanyiso, Dr. Leandi Murimo and Rutendo, if you could engage us on whether the exemption that is provided by the Immigration Act, that you apply straight to the Minister of Home Affairs. But from the founding affidavits, what I was reading was that if you apply and your purpose for the application is to practice law, they have reverted back and given a meaning to say that that's subverting Section 24 or 24(2)(b) of Legal Practice Act. So do you think that the justification can sustain in a constitutional democracy such as the one that South Africa practices? I think your marks. Rutendo, you wanted to say something?
I know you were first. I can follow up.
I'm not sure if it's my network, but she's breaking off. Is it me only?
No, can't hear. It's breaking up. And Kanyiso's microphone was not on.
Yes, I think Kanyiso, you can start off the conversation.
Sorry, Kanyiso, I did just enable you to switch on your mic, so you should be able to unmute yourself now. Okay, unfortunately, it looks like he's unable to unmute himself.
In the meantime, Dr. Ndimurimo, would you mind starting off the conversation?
Yeah, good evening, everyone. Thank you so much for inviting me. And I think this is an interesting case, especially when one looks at the Immigration Act as well as the Refugee Act, and also the obligation which South Africa is a state party to the 1951 UN Refugee Convention, as well as the OAU, now AU Refugee Convention. It seems that this case is quite interesting because it's gonna go, I think, in the view of the court, they need to look at the parameters of both international law as well as regional laws. So it's pity that when maybe I didn't introduce myself correctly. Yes, I am a permanent resident in South Africa. My nationality is Tanzania, and I've been here in the country since 2000. And the same Legal Practice Act, I think, had some somehow, some way affected me in a way, because when I arrived in South Africa, I was a law graduate. I had my LLB degree from Tanzania, and I wanted so badly to practice law in South Africa because that's where I was now residing. But unfortunately, I couldn't be allowed to practice by then because the requirements were that only people who did their LLB degrees in South Africa could practice. As a result, I was, when I approached some firms or whatever, my applications were simply rejected because of that, of not having an LLB degree from South Africa. And I was advised to either consider doing my LLB degree again in South Africa, something which I thought I wouldn't do at my age. And that prompted me to go to the academic route. And although even in the academic route, it wasn't that easy, and it hasn't been easy. And I'm grateful that in this room we are having, I'm having my bosses are here, so they know me very well. And I believe whatever I'm saying here they can even attest to that. So simply, maybe briefly, what I can say with regards to this case actually triggered my thinking on the application of the laws and policies which have been made by the government. Yes, the Union of Women's case is an important case which one can look at it in different angles, not only in the angle of South African laws, but also in the angle of international laws and regional laws. And also, we mustn't also forget the aspect that the labor laws also can feature in as well. And when it comes to issues of discrimination, not only one has to consider maybe a specific grounds as stipulated in the Constitution, but also one needs to look at other laws as well. For example, the issue, there is a nice piece of legislation which is the Employment Equity Act of 1998, which until now, I don't know whether it has been unpacked to try to look at how its application features into the issues of non-citizens in South Africa. Maybe for the moment, let me pause here because I like to talk too much. Let me pause here. Thank you.
Thank you so much, and hopefully I'm audible now. Yes, yeah, okay. And good evening to my fellow guests today. I must confess that I feel very much intimidated to be among the academics, and and thanks to the organizers for the invitation. The case, to me, it's a very important case because South African foreign policy prides itself to, the globalization concept. And I think that if we look into what South Africa is geared or is going today, the direction in which the country is undertaken in terms of trade and in Africa and the rest of the world. So this case is so important that legal services no longer need to be confined within a region or a certain district or country. Because we now speak about environmental law issues, we now speak about global tax abuses, of which I think, in my view, they really concern the interconnectedness, of the world in terms of the markets and so forth. So I believe that the exclusion on the basis of nationality or on the basis whether or not you're a South African citizen, they are in fact discriminatory on the grounds that in other regions or in other countries, the rest of the world, usually the test is just that you have satisfied all the academic requirements, be it to take a board exams of a particular country. I'll make an example. In countries like United States of America, you have the New York bar that normally, once you have an LLB from the foreign country, or even the LLB that you get, the JD that you study in the US, basically, even if you are not from the States, you are actually able to sit and write your bar exams and get admitted so that you're able to practice law. So my view of it is that this is a very important concept and is a very important case as well, because it's going to open an opportunity for most immigrants in South Africa, particularly from the SADC region. I think this is a very important region for South Africa, for it to survive. I mean, from the competition and trade perspective, this is a very important region. We've seen with what has happened in Mozambique recently, all that really concerns cross-border issues and jurisdictions, of which I think that South Africa, it being a very important player in that in this region, it's important that we allow immigrants who are coming from other countries that have studied an LLB and satisfy all the academic requirements to be able to practice law in South Africa. Thank you. Thank you.
Yeah, thank you so much, Nkanyiso, for your contribution. As a follow-up to what you said, South Africa ratified the World Trade Organization Treaty, which forms part of its law in terms of Section 38. It also ratified the African Free Trade Agreement, which allows for free labor within the SADC region. So then, is this limitation, then in the context of this case, unjustified, irrational, and an infringement upon those treaties? If Dr. Leah could illustrate, I know this is the area of expertise. Dr. Leah?
Thank you very much. I was hesitant because I was not sure whether the question was directed towards me. Could you please rephrase the question again?
Yes, following up on Nkanyiso's contribution on the importance of SADC operating as a competitive unit. South Africa has ratified 2 treaties that allow for the free movement of labor between countries that are signatories to those two treaties. Of great importance is the African Free Trade Agreement, that in clear and explicit terms state that there must be free movement of labor within the SADC region. Then if South Africa is a signatory to that treaty, is Section 24(2)(b) justified in the context of this case?
In my humble view, something was going weird. Yeah, in my humble view, I think it won't be justified, in my humble view, because that would be contrary to the demands of the treaties which South Africa has signed. And again, when it comes to the sub-regions like the SADC, for example, if the section in question will be kind of upheld, it means it will be defeating the purpose of the treaties which South Africa is a state party has ratified. So in my humble view, I don't think so.
Thank you, Doc. I see that there are 3 hands. I think Mr. Wacha was the first one, then Dr. Malekana and Prof. Botha in that order.
Thanks for the platform. I had the unique pleasure of chatting with the former Minister of Trade and Industry, Rob Davies, and in our engagements we were talking about exactly this, about the free movement of legal services in the region and globally. In my understanding, and I think he concurs, is that at this stage I don't think the Africa Free Trade Agreement quite caters for the free movement of legal services. I stand corrected, but I think that was the position that me and the former minister came to. However, it is still catered for in the World Trade Organization, as you rightly point out, and the sub treaty called GATS, the General Treaty on the Trade of Services. And so there's an interesting element that I think I hope is explored in the case, that where services can move more freely, it is actually a benefit to whatever industry, because foreign investment then flows from that. So these are the type of nuances that we're hoping to explore in this case. So thank you for that very insightful question.
Thank you, Dr. Ramalekana.
Hi, so I want to sort of pick on what Dr. Leah sort of brought into the room earlier on. It's the question of the Employment Equity Act, which is, I think, the elephant in every room on this issue, because the issue that I think Dr. Leah was pointing at is under employment equity legislation at the moment, employers don't get any sort of employment equity points, if we'll call them that, for non-citizens. The Employment Equity Act specifically defines its beneficiaries on the basis of race, gender, and disability, and expressly excludes non-citizens, right? So there's a requirement of citizenship. And I guess my question is to the community of legal experts here and everyone in general, like, what is the argument on the part of the employer if they come and say, well, the reason why this kind of legislation makes sense is because for an employer, they would not be able to comply with employment equity legislation if they were to employ persons who are not South African citizens, because I think we need to solve the employment equity legislation as well. And this links on to another sort of issue that I was sort of coming to as I was listening, is the exceptionalism of the legal fraternity and how it sees itself as this super special community, and the problematics of that historically, and how this legislation is also quite closely linked to that. I think one of the things that the founding papers does is it explores the racist history of this exclusion. But I think what I'm trying to bring in the table, in addition to that racist history, over and above its xenophobic context at the moment, is legal exceptionalism, and sort of something that we need to also be talking about, as we are also talking about how do we cure provisions of the Employment Equity Act that would also exclude non-citizens, or do we think that employment equity legislation is performing a different function, one that would allow it to be exclusionary in this way? So I don't have answers to this, but these are just questions that I'm putting on the table. Because an employer can come and say, even if non-citizens are allowed to qualify as legal practitioners, I still won't hire non-citizens or persons who don't have permanent residence, because I wouldn't be able to then meet my targets under employment equity legislation. So I'm just sort of bringing some of these other questions in the room. So like 2 questions really.
Thank you so much. I see that Ms. Nichinguri has got her hand up. She seems to have lost her connection. I think she's back on now. Then I'll get to Prof. DeVos.
Okay, just checking if everyone can hear me. Okay, just checking if I'm audible now.
Yes.
Okay, first of all, I'd like to apologize for the lack of video. I think if I say load shedding, everyone in the room can relate. So I'm a victim of load shedding at the moment, so I had to connect using my phone. But thank you very much to the panelists, such insightful opinions. And before I lose my network again, I'm just going to give a little bit of background about my experience. I had the privilege of being signed by Bowman Gilfillan then. It was in 2015 actually. I was in my 3rd year, and I was signed to start my articles in 2015. But at that time, I think that's when they introduced the Department of Labor requirement, which was a very strenuous requirement whereby the law firm had to verify the number of South African citizens that had been interviewed with me, and to justify why they were picking Rutendo over other South Africans. So I think that view of mine can sort of show that it just doesn't end with this alone. I think even now, I don't know, maybe 5 years ago, a lot of law firms stopped interviewing or just foreigners, how difficult it is to justify why you have picked a foreign national as African. So there are quite a number of hoops that are put in place, and I can say when my permit didn't come out, I think it was quite a very depressing period of time for me, because I'd done everything by the book. My fees was paid in full. I had gotten distinctions. I had worked very hard, and just to be told that the Department of Labor is of the view that there were other South Africans that could have been taken by Bowman's. So not only does it take the agency of the company itself, it also, the harm that it brought. I think Prof. DeVos had spoken of the harm, and I'm still living with that harm 4 or 5 years from now. But overall, I think that's one of the aspects that I wanted to bring out, that the fight that Mr. Mchengeti is on is not only for those who are ordinarily resident, it's for every student that has chosen South Africa as a choice destination in the hope that they can practice there. I think it would be interesting for it to be a wider conversation in that context. So thank you very much.
Thank you so much, Rutendo. Before I get to Prof. DeVos, I'm sorry, Prof. Water, I think I forgot. I thought I had recognized you. Please forgive me. I think you can come before Prof. DeVos comes in.
Okay, I promise not to be long. I thought I would just bring the discussion back to this particular case, and having read the paper or the affidavit, I was really interested to see the analysis of foreign law. But the analysis of international law, putting that onto the papers, it wasn't there. And we were talking a moment ago about world trade agreements, etc. But, you know, we've also ratified the ISA, the International Covenant on Economic, Social and Cultural Rights. And whilst the right to work is included in the ISA, and certainly in our constitution in section 22, I saw that question posed a moment ago, that right is only afforded to citizens. But what we need to remember is that the ICCPR and the ISA, these treaties also obligate South Africa to afford rights without discrimination. Okay, and section 233 of our constitution specifically says that when we interpret legislation, we must give that legislation interpretation with accords with that in international law. And so even though our section 22 only applies to citizens, section 9 and section 10 apply to everyone. And very cleverly, the affidavit has been pegged on sections 9 and 10 and not section 22. But if you read all of those together, and if you have a look at General Comment 20 coming from the committee on the ISA, it's clear that these rights should be made available to everybody without discrimination, and nationality is specifically listed there. So not only does foreign law support the argument, but so does international law. And that is, of course, is coupled with everything in relation to African free trade, etc. To me, this is an anomaly, and it's an anomaly that really must go. And I would urge any court that hears us to use the interpretive exercise to extend the rights to foreign nationals in our country. Yeah, thanks.
Thank you. Prof. DeVos.
Yes, so I was wondering now, Nomfundo's question is, of course, politically, it's a very important one. For this case, I wonder if the arguments that the Constitutional Court used in Khoza versus Minister of Social Development will not be relevant, because there the court said, where it had to decide whether permanent residents, admittedly permanent residents, could qualify for various social benefits and grants. And the government said, well, we don't, these people, so-called, are not South Africans. It's South Africa first, so to speak, to use one of the political party's slogans. And so we have a right to, there's a legitimate purpose in excluding permanent residents from these benefits. And the court rejected that. And they said, well, you as the government have let people into the country, gave them permanent residency, as the litigants in this case were given the right to work. And now you are blaming other people for what you have yourself done. And so I think that is quite an interesting or strong argument. It doesn't get you to the redress, the employment equity, but it does get you over the argument that this is done to protect the legal profession, or to protect poor and vulnerable lawyers who cannot make 5 million rand and only can make 2 million because this foreign person is going to work. It protects, it dismisses that argument, or dispenses with that argument, I think, in a powerful way.
Thank you so much, Prof. Thank you so much for your input. Ms. Muchingur, is that a legacy hand, as advocates here would put it, or it's a new hand?
No, my hand is not up.
All right, thank you. Going back to the
We missed now the sound.
Yeah, I also can't hear anything.
I think Tinashe is experiencing technical glitches. My name is Jukumbere Nyika. and I'll just take over till Tinashe sorts out his network situation. All right, moving on to Dr. Leah. I see your hand is up.
Thank you very much. I think there is also another important case which maybe one can look at it. I'm trying to scratch into my document. Oh my gosh, is the Somali Association case. And in that particular case, if I'm not mistaken, it was highlighted that at least a right to operate business also can be taken into consideration. And this also translates into the right to human dignity and equality as well. So that's what I was trying to highlight, because when we think of right to work, it not only in the legal profession. I think in the invitation, there were some aspects which were highlighted when we compare, let's say, the legal practitioners versus other professions, like your medical practitioners or your accountants, your pharmacists, and so on. It is interesting to find out that it is not only in the legal profession, and that's what, if I can recall what Professor Bota was talking about, when we look at what the issues this case has brought about, is not on, it mustn't be confined to the legal profession as well, or to the Legal Practice Act. We need to look beyond that. We need to look also to look into the other professions. For example, if you can use the medical profession as an example, yes, non-South African citizens can be allowed to practice, but when they graduate, for instance, remember, to practice as a medical practitioner, you need to do to do an internship. You need to do community service. But non-citizens will be the least priority, and as a result, to be registered as medical practitioners as a non-South African, it is a problem. So yes, this case is focusing more on the legal practitioners, but I think other avenues, especially in the broader context, or to try to look the law holistically, we need to go beyond the Legal Practice Act. Thanks. Thanks.
Thank you very much, Dr. Ndumurimo. My next question is for Kanyiso or Dr. Ramaleka. The question is, as a young South African, what are your thoughts? Because they are affirmative questions here that obviously you can address the area, that the admission of other nationalities does also take the job space. But what are the thoughts of the general South African about this? Because also, of course, there has been xenophobic statements about this and xenophobic chat around this matter. So what are your thoughts on a personal level, not from an academic perspective, but on a personal level as a South African?
Oh, thank you, Energy. If I just go first again, I think that South Africa is known for its xenophobic nature, and I don't know if you would understand me if it feels like it's a general statement, because most of the government officials have been a number of times on camera, on the news and elsewhere, denying the recent xenophobic culture in South Africa, the hostility and the stereotypes that exist in South Africa. Even that the policy seems to be, I think it's Mamdani who speaks at length about South African exceptionalism, that we geographically identify more as a European country other than being an African country. So hence, I think the hostility and also all these preconceived ideas against African immigrants. So my personal view is that, this xenophobic culture in South Africa manifests itself in different fields and different areas, not only in law, but in society at large, You've seen normally the city of Johannesburg, they have an entire xenophobic campaign called Ukai Molao. So we just stop random people whom they perceive that they are foreign and therefore they do not have proper documentation. I mean, you have a program or a xenophobic program that's being championed by the government. There was a recent bill in Gauteng. The Gauteng provincial government wanted to exclude business that are owned by the immigrants, and that bill has failed. But so that attitude, it's most likely to inculcate to the minds of South Africans, because one is championed by politicians and very powerful people in our society. So I believe it's an ongoing issue that we have to deal with. For us to be able to even find a solution, even from the legal fraternity, we have to deal with this issue in its entirety, because it's a problem in our country that we have this xenophobic culture that we have embraced.
Yeah, I won't add anything more than what Ungangiso has added, but more just to echo and to support his approach and his thoughts on this. But just to say that, even before Ukai Molao, even before Trump was talking about building a wall, in 2015 we had Operation Fiela in inner city Johannesburg, along the same xenophobic lines. So quite, this concept of necropolitics that I was talking about earlier is quite embedded in sort of our xenophobic culture. It's like othering non-citizens and targeting them for state repression using the law. That's something that's quite embedded in sort of our culture. Speaking as a person, an individual, I mean, I support this case because of, my personal politics, and my politics are that, we are Africans, and this is, if we are going to talk about Pan-Africanism, we're going to talk about a Renaissance, we're going to talk about decolonizing law, decolonizing our lives as Africans specifically. This is where it's to start. Of course, I'm not restricting the changes in the Legal Practice Act to just being focusing on other Africans. So that's not what I'm saying, but I'm saying that a part of my support as personally, which is the prompt, is like I deeply believe in this value and in this virtue of African community and the work of, really building a new world for ourselves on our own terms. And I think the law is a big part of that. And it also involves then creating community across borders, especially a strong legal community across borders. So that's my personal sort of reason as to why I think this is an important case. And I hope that it expands to other areas where there are similar restrictions. I saw comments earlier from students, and I think this is something that we should talk about, is the fact that so many South African universities have been profiting from the double fees that non-South African citizen students are paying to be in these institutions. So that is something we should also feel indicted in as law faculties, that we are educating a community of students that we know is going to be subject to discrimination when they leave the classroom. And our activism should be rooted in wanting to do better for them as well, especially because we charge them so much as institutions and we make so much money, which is another issue that we should discuss on another day. But yeah, I just wanted to respond to that question from students.
question actually came from Advocate Kotsia. She's the Deputy Dean at Nelson Mandela University. So yeah, just for that clarity. I think this will be the last question. Before I had a power cut, I wanted to ask Prof. Porter that the applicants in the affidavits state that the task team that was mandated with the task of drafting the Legal Practice Act actually wanted ordinary residents. The majority voted for ordinary residents for one to practice law in South Africa. However, when the legislation was enacted and promulgated, the minority decision was the one that was taken up. What is the probative value of that to this case, if there's any? And a follow-up question to Dr. Leah. From a comparative laws perspective, the applicants heavily rely on laws from Mozambique, from Zimbabwe, from Zambia, which do not necessarily need one to be a permanent resident or a citizen to practice in their country. Like, for instance, in Zimbabwe, they talk about reciprocity, which is not necessarily, if our laws are almost the same as yours, you can come and practice. Do you think that it will sway this case in a certain direction, hopefully in favor of the applicants?
Did the first question come to me? I didn't quite hear.
Do you want me to reiterate it?
No, not at all. I just didn't hear if you put it my way, but I was also seeing that Tim Fish from ICJ has been wanting to come in for quite some time. So perhaps if it's okay with you, he wouldn't mind coming in just before me, and then I can come in after that.
All right, that's perfect.
Thanks.
I think he's been there for a while. Tim, are you there?
Yeah, can you hear me?
Yes, I think you can go ahead.
Okay, I mean, it's probably not good that I'm going so close to the end because what I'm going to say is quite depressing, but be that as it may. I think that Professor Botha is right about the international law perspective and the Covenant on Economic and Social Rights and the ICCPR as the jurisprudence of those committees stand today, but not necessarily as they stood 20 years ago. And that's the reason the ICJ is intervening or applying to intervene as an amicus in this case to make those arguments specifically. And also an argument on the fact that restricting arbitrarily who can be a lawyer and who can get what lawyer is a violation of the principle of the independence of judges and lawyers, which is very important in international law. And the ICJ stands very much for not having random and irrational restrictions on it. But the downside and the depressing part of this is that really the Constitution is a xenophobic document. Section 22 of it is without merit and justification. And if you look at the discussion that led to it, it was also xenophobic and without merit and justification. And so is the judgment Professor De Vos is talking about. I think we should argue around it, but I think we should also accept that we have I understand there's strategies that non-citizens are adopting to little by little use the right to dignity, use international law and other rights, but this obstacle is too powerful, and if it remains in the Constitution, the fact that trade and occupation are rights for citizens specifically, I think that that's a problem waiting to happen for a demagogue or a fascist later down the line, and really we need to eventually combat this problem. And the problem of xenophobia on the early Constitutional Court, which allowed them to both acknowledge the problem of xenophobia, but then hand down xenophobic judgments at the same time, which I think Professor Vos has hinted towards. And Nomfundo's point, I think, is also interesting because what I would worry about bringing the Employment Equity Act in, and it happens in this discussion all the time, is that one of the assumptions that many employers have is that the only reason to employ black people is because they get points. And because you're a non-citizen and you're black, but you don't give points, so the base is now we're going to default to employing white men again, right? Because that's the standard, is that we employ white men, and then when there's some incentive, then we. So really, like the Employment Equity Act discussion is one that gives me some trouble for that reason. Although I think that obviously we have to try and be pragmatic as well as ideological. But overall, what I would say is that we can use international law, and we should, and we can use it through rights like dignity and argue equality arguments and independence of lawyers arguments and all of these things. But I wonder when the time will come where we can publicly say that this section in the Constitution, which gives so much confidence to the people in the Department of Justice who really believe in these types of restrictions, and to the people in the government who produce xenophobic legislation on national, provincial, and local levels all the time. Really, we have to take that confidence away, because there will be a Herman Mashaba who succeeds. This is what we've learned from the last 10 years of fascism around the world. And then that provision in the Constitution will be too powerful to get around, even with progressive judges. So that's just what I wanted to say about that. Thank you.
Thank you, Tim, for that contribution. I think we're running out of time. Prof. Botha and Dr. Leah, would you mind wrapping up in the next 4 minutes?
So I've had quite a long chance to speak, so I'm not going to say more other than it's fantastic that the ICJ is coming in as an amicus. I think that will make it really exciting, and I really wish the coalition well with this case, and also the applicants well. And I think the time has come for this type of case to come before court again. It's been some time since Union of Refugee Women was decided. I think, Nomfundo, the point that you make about employment law and where this fits in requires us to take a broader picture view on what our government is actually doing and saying when it comes to nationals. And, all of this is coupled with the fact that we know that the immigration system in this country is highly inefficient. You can sit waiting for years and years and years and years. So please don't tell us that, we'll sort your case out. We know that's not going to happen. So let's be pragmatic, let's be real, and let's really, I think, put our money where our mouth is and live the good parts of our Constitution. So I'm going to leave it there and hand over to anybody else who wants to speak. Thank you.
Yeah, thank you. I think it's my turn. Is it so?
Oh, yeah, yes, ma'am. Regarding the probative value of comparative laws that the applicants.
Yeah, thank you very much. The probative value of comparative, I think that can make sense, because if I can use again my example of myself, because I did LLB in Tanzania. Tanzania follows English common law, and that's why it wasn't even difficult for me to plug in when I did study in South Africa. So yeah, I can see the value on that, but also I'm glad that Tim just mentioned Section 22. Which is more specifically meant for the citizens, and that would be a kind of something which have to be looked at. I like the way Nomfundo has raised important issues with regards to employment equity. I support that. So I think that can help. Especially when you compare, remember when we do comparative analysis, yes, it may be not authoritative yet, but at least there'll be some sort of persuasive value in it. So that is my take on that. But again, our Section 22 is an obstacle. Thank you.
Thank you so much, Dr. Ndimurimo. I think I have exhausted my time here. Thank you so much to the panelists. I would like to hand over to Sibusele Lemazini, who will do the question and answering session. Thank you so much.
Evening. Can everybody hear me? Yeah, I just wanted to say, first of all, thank you so much to the panelists. I think this was a very needed conversation, and it came at the right time. Is it okay if we go perhaps maybe 10 minutes overboard? I've gotten messages already on WhatsApp from different students itching to ask questions. So I think how this is going to work, I've been keeping my eye on the chat, and there's mainly been questions surrounding Section 22, which I think Prof. Buerta has already adequately answered. I'm going to also be taking hands. So those who have had their hands up, unless you're asking a question, can I please ask you to put your hand down so that those who do have questions can come through? So you guys can start raising your hands if you do have questions. I know that Wongale Tusimaile had his hand up for quite some time. So Wonga, you can come through and ask your question, and then, yeah, we'll move on to the next.
Thank you, Sivu. I already made a point in the chat box. But yes, I wanted, I hope I'm audible.
Yes, you are, we can hear you.
Okay, yeah, I just wanted to hear some a discussion on the state of unemployment in South Africa, because we cannot have this discussion in isolation of that. I know what we rush to do and quickly conclude is xenophobia, but I have no particular feelings that are negative against any foreigner, especially one that is coming from Africa. But I do not think we should at any point give our already limited jobs to foreign nationals. You know, I understand our commitments with regards to refugees and all of that, but South Africa has already limited jobs. You know, we are in an unemployment crisis. And that must be part of this discussion. That must be part of the consideration as to whether should we allow, because it's not just limiting foreign nationals from practicing, it's limiting them from taking or getting employed in place of South Africans. You know, there are limited jobs in the legal fraternity, and so we must consider that. Should we give to foreign nationals our jobs or limited jobs on the basis that restricting them or excluding them is a violation or is a limitation of their human rights? Is that limitation not justified by the fact that we are in an unemployment crisis and as a country are not in a position to, we don't have enough jobs for us. So can we then give to other people? You know, is it rational to expect us to give jobs to other people when we don't have enough for ourselves? You know, it's like the parable of the 10 virgins. You know, you don't have enough for us, so we can't give to you. I think that's what is happening here. We can't give foreign nationals jobs, so that's why we don't. But yeah, anyway, yeah.
Yeah, sorry, I just wanted to make sure that we have enough time for other questions. Between all of the panelists, especially, I'd love to hear from those who have already been through the system and are affected by it, what your opinions are on the question of, you know, the socio-economic position. So if there's any panelists that would like to, yeah, start us off, I can see nervous faces at the moment. Rutendo, perhaps, Dr. Leah, Nkanyiso, anyone?
Can I say something?
Go for it.
But it seems to me there's an assumption in the question about us and who's not us. So that's an interesting question. How do we decide who's us and who's others? And human rights is very much about thinking and challenging these ideas that there are in-groups and there are out-groups. But I'm not an economist, but I do know that I have read research reports that argue or find that immigration is good for an economy. People who come from all over to a new country are people who have drive, have determination, and so on. Sorry? So the basic assumptions maybe of the question I would want to interrogate further because I'm not necessarily sure that they are factually correct at the very least. So that would be my.
Yeah, since I was among the people whom the question was directed to, yeah, my take is immigration is a global phenomenon. And trying to respond to the question by Wonga, I think, I believe that the socioeconomic issues which we are facing currently is not just have been brought by the foreigners or non-South Africans. And also, if we go to the statistics, we find out that especially currently, many professional South Africans are not in South Africa. They are working somewhere else, like your doctors, your nurses, and as many as we can take. So trying to justify that having xenophobic laws and policies which discriminate against non-foreigners or non-South Africans is not a justification that we are going to solve all the socio-economic issues we are having in the country. That is my take. Maybe one may tend to disagree with me, is fine, but that's how I look at it. Another thing is, we mustn't forget that these non-South African citizens, they do contribute to the economy. For example, in many ways, paying tax. Let's say if I use myself as an example, I started working at the university since 2006 until to date. I have produced students who have gone up to the level of PhDs, and I'm proud of myself that I have contributed something. So it is kind of a sweeping statement to just say that these non-South Africans are taking our jobs. We don't have enough employment. Yes, that is a global phenomena, but it cannot be justified. That is, maybe that's what I can say for the moment.
Rutendo, you had your hand raised, and then Muchengeti, please come in after her, and then we'll go to the next question. Rutendo, your mic is still muted. Okay, I'm going to swap the order. Muchengeti, can you please come in, and then we'll have her come in after you.
Thanks very much. I'm going to just sort of follow on the 2 points made by Professor De Vos, is that, yes, I think I concur with the studies that say that immigration more often than not is a benefit to an economy rather than a drain on an economy. And I think also the perspective is very limited, where we think that we are sort of the outcome will only be something that takes jobs from South Africans. Look, what's likely going to happen if we're successful is that a lot of non-citizens are going to establish law firms, going to establish practices, and employ South African citizens. So we may actually find that this creates jobs rather than takes away from jobs. And I think the academic research supports that notion. Yeah, thank you for that.
Rutendo, are you able to unmute your mic? Okay, I think she might be having connection issues. We can move on to the next question, and then if she's able to resolve it, then we can just come back and just hear what her thoughts are. Farisai Jaka, your hand is raised. Please unmute yourself and ask your question.
Good evening, everyone. Can you hear me? Okay. Hi. So I just wanted to ask, I don't know if you've heard the phrase "put South Africans first." That's been kind of circulating in the field of politics and media and so forth. So I wanted to ask the panelists what your thoughts on that phrase are in the context of this conversation and in the context of South African employment in general, because the Constitution does specify South African citizens in a lot of its provisions, and that's the argument that a lot of people have who support that statement and that whole belief in general. So do you think that statement is justified in some aspects? Do you think it makes sense in some aspects, and in what aspects would you say it is not justified? Thank you.
I'm happy to come in just very briefly on that. I think, we're talking about socioeconomic conditions here as well, and many of the cases that have been litigated do concern Section 26 and 27, and we've also seen litigation. I'm happy to come in just very briefly on that. I think, we're talking about socioeconomic conditions here as well, and many of the cases that have been litigated do concern Section 26 and 27, and we've also seen litigation based on Section 9 and Section 10 insofar as foreign nationals are concerned. And all of those rights vest in everyone. It's mainly Section 22 that vests only in citizens the right to work. So, all of those rights intersect with one another. And I think at the end of the day, if we, despite in terms of misgivings, if we do look at various rights that are in our Constitution, they do apply to everyone. And Causa demonstrates how that can be used effectively. So, a bit hesitant on I don't like this, South Africa for South Africans argument. We're part of the family of nations. We have people who've entered our country legitimately, who are asylum seekers often, who are refugees, who have work permits, study visas, etc. And we shut the door here. It's just not acceptable in my view. I see that Nomfundo wants to come in.
Not to add anything more, but to say one of the things that we can accept is the limitations in Section 22, but there's also this idea that the right to work has, in our constitutional jurisprudence, been quite closely tied to the right to dignity, and actually in the founding affidavit, I think the argument is hinged on Hoffman, so the Hoffman analogy on economic death, but the is like jurisprudence directly on the point of Section 22 itself. Being tied to dignity, and if dignity is a right that everyone is entitled to, perhaps to be a little bit more optimistic than Tim in this relation. I think there is a way to go around Section 22, because we are trying to find a pragmatic way of helping our communities right now. So before we get to the ruins of a new constitution, here is one way, the way that Section 22 has been read to be closely tied to dignity. So just really adding on to what Prof. Botha was saying, is like if we read the rights interconnectedly and in a coherent way, and we see the values in the Constitution performing that work, dignity could be a place where we hinge an argument that could push against a limited interpretation of Section 22 of the Constitution. Yeah.
Hello. I don't know if I should come in to just like add a little bit on the Put South Africa First question. And I think to me, it's just a rise of, populism in politics. I think that's what just prompted, this South Africa. We've seen this in the US with the rise of Donald Trump, the Trumpism ideology of putting America first, of which I think we've seen outcomes and the perils of that it really backfired economically and otherwise. So I think the entire concept that South Africans themselves, have to be put first and other people, it actually diminishes other people's humanity, that they exist, they're in our country, and they are also human beings. So hiding behind nationality and all these things that we create for ourselves, an illusion that because I have a document to be in South Africa, therefore I'm the only one who have got rights to have access to economic activities and so forth. I think it's just a contrary of what South Africa prides itself on, and human rights paradigm and so forth. So it's a very shrewd idea, and it's deeply rooted to the Russian nationalism of South Africa.
Maybe if I can just come in there, I've just made the point in the chat box that look, a lot of the larger law firms are already integrating themselves into the business framework in Africa and beyond, and sort of solidifying those relationships. And South African legal practitioners work in the region regularly. And maybe just to put this one to bed regarding Tembeka Ngcukaitobi and Advocate Dali Mpofu, which always comes up in these discussions, is that the main reason for their frustrations in Zimbabwe was political. And funny enough, they were actually given the licenses to practice or to represent their clients, but after the fact, after the end of the case. So yes, there's a long history of South African jurists working in the region as judges, as practitioners, and so it's very disingenuous to then say that when it comes to our own jurisdiction, we'll then put up walls. That's just my 2 cents on the issue of Put South Africa First.
Thank you so much. I just wanted to ask a question. There is a question in the wait, there are 2 questions that I want to ask, and then I think we should definitely move towards a close. There was a question that came forward to Professor Pierre de Vos in terms of UCT. Apparently that they only take about 9 to 10 LLB students, and the question is like, how is UCT working around balancing, taking in foreign nationals for the program and then the issue of affirmative action?
Okay, so I'm not actually sure if there is any, I don't think we have any kind of limit on foreign nationals allowing people into the LLB. I've sit on the committees, but maybe I didn't listen when they discussed that. It's very boring in these meetings. But it's my understanding that just as the Employment Equity Act, when it comes to for redress purposes, if you're a foreign national, whether you come from SADC or the rest of the continent or from the United States, it doesn't matter. You can get in, but there are, of course, the academic requirements. If you are not from SADC, it's in the interest of UCT for some of the reasons that Nomfundo said, for us to let them in shamelessly for money, because you have to pay very high fees. One of the reasons why the law faculty claims now to be broke is because all the foreign students from Europe are not coming to study because of COVID. But as far as I know, and I'm relatively certain, there's not foreign nationals are not treated differently for reasons of admission. But of course, sometimes there's a difficulty in translating the qualification that people got in South Africa to what they got in another country. So maybe that translation is not always perfect. So I would think that.
Okay, the second question has already been answered in the chat by Prof. Botha about whether or not, if the case is successful, whether or not it would have effects on other provisions that that have to do with South African citizenship, and she's already said that she doubts that would happen. But I think my question is just in general. I think, yeah, I'm going to take up the last question. I hope nobody minds. As law students, we are particularly, or personally, I feel like we're forced to choose between, you know, going the attorney route or the advocate route, and there's no other, you know, venture for us to look at. And I think my question is to panelists, what advice would you give students? Because obviously this case is still going before the court and we're waiting to hear a judgment. But those who are about to graduate this year and next year, do you have any advice in terms of where they should be looking to go in terms of employment and what to do, especially for those who are foreign nationals and are currently facing this problem? Yeah.
Well, if I just come in, my advice for law students in their final year is that there's quite a number of organizations that they can work for. There are human rights organizations. You have got the UN. You have got, I think the UN has got quite an extensive internship program. And there are opportunities also at the Constitutional Court where you can work as a clerk at the Con Court. And I mean, there's just like a variety of options that you have other than going straight to practice, like going to chambers or being an attorney. So I think students should look into those opportunities. For instance, UN has got paid and unpaid internship. You would need a lot from your professors, such as recommendation letters and stuff like that. So I think that they should also look into those opportunities. Yeah, so that's my advice for final year students.
I see that the two academics from our faculty, Prof. Botha and Dr. Ndimuruma, obviously decided to comment of going the academic route. Dr. Ndimuruma, I see that, yeah, that your mic is unmuted. Did you want to say anything to add on to that by any chance?
Yeah, I just wanted to add on that because as I indicated before, my initial idea when I came to South Africa was to practice either as an attorney or an advocate. Then because of the hurdles from the Legal Practice Act, that's when I made up my mind to go to the academic route. And I think I'm happy where I am to be an academic. So I would also like to advise students to go to the academic route. But also there is a price to pay because you need to read and to go to school, and because with your LLB degree you won't be an academic. Even when you get your LLM, still not that great. At least you need to go further a little bit and have your LLD. And even after having LLD, you don't stop there. You need to continue to do research. I think that is my advice.
Okay, there's no one else that wants to take a swing at this. I see that there are comments in the chat about doing research, having research positions at the NGO, and that Amnesty International has paid internships. So please, yeah, the students that are on this call, definitely please click onto the hyperlink. I think it would be very useful. I'm going to hand over to Zviko to do the vote of thanks. Yeah, we've definitely gone 10, almost 20 minutes over time. Yeah, Zviko.
Hey again, my name is Jukumbure Nika, and I'm the ZIMSOC Deputy Chair at ECT. First of all, I just want to thank our panelists. This has been an engaging conversation, quality all the way. Obviously, I'm a Zimbabwean, so this conversation is a personal one, and as a student, you're not too sure what's going to happen. I mean, often we feel like we're the 30th tribe of South Africa, but I think this has been a great conversation, and we can see light at the end of the tunnel. And also I want to thank the viewers that have stood with us. Even though we went over time, we've had good numbers over time. And I just want to say to all those that also came through to voice out their concerns, like Mr. Muchengeti, who's part of the coalition's case. Thank you very much for coming through and giving us your insight. And yeah, so thank you very much to everyone who came through. This has been a success, and hopefully the two universities, Nelson Mandela and University of Cape Town, continue to collaborate and foster a space where we can grow the African continent to the next heights. So thank you very much.
Thank you very much.
Thanks, everyone. Bye.